Hello, and welcome to the Face of Vulnerability. I'm your host, Dr. Zena Crenshaw-Logal. We're filming at the Rod Logal Center for Justice, namesake of my late husband and fellow human rights defender, Rodney A. Logal.
It is November 2018. We began with a quote attributed to Michelle Bachelet, the United Nations High Commissioner for Human Rights. We are less than 2 weeks from the 20th anniversary of the Declaration on Human Rights Defenders being adopted by the UN General Assembly, and almost exactly 70 years since that body adopted the Universal Declaration of Human Rights. Yet attacks on human rights defenders around the world have reportedly escalated to a crisis point.
I invite you to consider how this crisis manifests in the United States of America, not just in terms of human suffering involved, but also the impact on America's form of government attributable to unchecked persecution of human rights defenders by rogue agents of U.S. government. Allow me to propose that we need to be clear on who exactly is vulnerable to this persecution and why they are, before democracy in America and our country as a Republican form of government are barely even a pretense.
Through this series, we'll look at who is at risk and gauge the atrociousness of harm suffered based on more than whether it was brazen. You see, the world puts a premium on blatant or brazen human rights violations, as if subtle or covert violations are inherently less brutal. In this episode, we'll look at judicial rulings with the potential to crush a certain form of good government advocacy in America by subjecting its biggest financial backers to economic duress. I assure you, the human rights defenders involved are outside what the world perceives as a highly vulnerable population.
But let's rethink those concepts. I am part of two protected classes established by federal law in the United States 54 years ago. Yet my demographics are very different from groups universally considered the most vulnerable to exploitation. They include women, I'm in that group.
Others are people living in poverty, children, migrant workers, people with disabilities, and older people. Obviously, I'm no spring chicken, yet it wasn't my age, race, or gender that left me increasingly susceptible to oppression by the second decade of me being a U.S. legal system reform advocate. So far, I've used the word exploitation. I mentioned oppression. In 2007, the word disadvantaged resonated with me. A prestigious anti-corruption organization known as Transparency International shared in its 2007 Global Corruption Report that all these are prerequisites for an environment promoting access to justice. The capacity of disadvantaged groups of citizens to gain access to courts by removing various institutional as well as corruption-related barriers within the legal system. Aha. Groups especially vulnerable to exploitation and oppression have the most obstacles to justice through court proceedings. There may be language barriers. Just being able to mail or hand deliver court papers can be a challenge. Many people can't afford the cost. Venturing out to government buildings is very dangerous in some parts of the world.
Buzzwords are desensitizing, but with these obstacles in mind, let's push past the jargon of human rights advocacy and embrace the idea that lawful access to justice is the great equalizer when it comes to human rights protection.
Of course, it takes a degree of wealth and good health to be part of court proceedings. But exploitation and oppression definitely signal a lack of justice, whereas they don't always signal lack of wealth or health. So, is anyone more or less vulnerable when a justice system becomes a charade? That's a game, an absurd pretense intended to create a pleasant or respectable appearance. In 2010, a stellar coalition of grassroots good government advocates suggested to the international human rights community that certain avoidable gaps in America's legal system allowed it to be rendered little more than a charade. On October 10, 2018, the Communications Division of the UN Human Rights Council confirmed that may very well be true. Opt-in USA is a grassroots U.S. foreign policy reform, judicial accountability, and human rights campaign. And it's also the context in which I elaborated on two basic points of a January 2018 complaint, prompting the October 2018 response from the UN Human Rights Council. One of the basic points is that over the last 20 years, certain gaps have been honed into America's legal system such that it can be selectively enforced. So much for inalienable rights. The other basic point is that interbranch comity has devolved into a de facto policy of judicial impunity for the role of judges in persistent abuses of America's legal system. That's right, America is too deferential to its third branch of government. Judicial oversight in our country is woefully inadequate. The problem began to become apparent in about 2002 when the internet allowed average Americans to share, albeit unverified, accounts of court-related nightmares. Those online sharing anecdotes learned they were not alone in their alleged suffering, and similarities, if not distinct patterns, of their court-related tales of woe began to emerge.
Again, by 2010, these complaints had evolved beyond this or that injustice and collectively suggested that America was not engaged in a fair and impartial administration of justice and seemed to have departed from the rule of law.
There was a clear, national, distinctly grassroots U.S. legal system reform movement underway. It was and still is premised on widespread accounts of sometimes third world caliber injustices, all of which are ultimately attributed to alleged judicial misconduct or the undue protection by judiciaries of criminal prosecutors. When you consider the sophistication and resources needed to overcome this situation with any mainstream appeal, the task beckons for human rights defenders who are classic examples of privileged people. Of course, brace their privileges against the weaponization of America's legal system, and you'll see them transformed into human rights defenders as vulnerable as any other. Or will you? Last year, the Center for the Independence of Judges and Lawyers, International Commission of Jurors, reported to the United Nations that global experience over the last 65 years demonstrates that a legal system that all actors know will respond effectively and consistently to violations and abuses has a general deterrent effect. Since 2005, Opt-in USA's nonprofit corporate sponsor has been at the forefront of establishing that America's legal system does not have that general deterrent effect.
The sponsor is National Judicial Conduct and Disability Law Project, Inc., also known as the Law Project. My late husband co-founded this nonprofit with me and our colleague, Dr. Andrew D. Jackson, in 2005.
We were three musketeers of U.S. legal system reform advocacy for nearly 2 decades. For that entire time and well before the Law Project began, my late husband was our primary financial benefactor. After years of my former husband, by himself or with me, fending off attempted incursions into his finances through court proceedings. A 2014 judgment was entered against him in his absence, supposedly for criminal conversion of $1,000. Yes, a judge ruled that Rodney A. Logal, who was more than 70 years old at the time, a longtime businessman and human rights defender. Yes, a judge ruled that this person, my late husband, supposedly stole $1,000 as part of his arrangements to clear a field for our former neighbors so their land could be farmed. Never mind that, per case law, a theft could not be premised on the underlying facts and circumstances. It was an underlying and unfortunate contract dispute. And escrowing $1,000 or collecting the related $6,000 judgment against my late husband never seemed to be a particularly high priority for his courtroom adversaries, at least not higher than viewing his banking records as well as tax returns and hauling him into court on contempt charges. Now, my husband and I were no strangers to litigation. He was a longtime businessman, as I indicated. I attended prestigious schools and was designated a scholar on multiple occasions, in addition to being a small business advisor and a pretty accomplished civil trial lawyer. But at best, all my husband and I could do was stall the inexplicable court-sanctioned aggression against him. By all indications, the stress of enduring that hostility caused Rodney to suffer two separate but simultaneous strokes in February of 2016. And before his post-stroke condition was fully assessed, despite my having notified everyone involved of his obviously compromised mental state and related communication difficulties, my ailing husband was again cited for contempt of court, a development the judge had previously assured him would get him jailed. The judge indicated if he had to come back to court on contempt charges again, he would be jailed.
The law, medical evidence, assurances that they risked killing Rodney, my offer to pay, outreach to former President Obama, his Attorney General, and my U.S. representative. None of that protected my husband, a man who post-stroke was relearning to write his name.
Yet Rodney was ordered to appear in court, presumably to explain why he should not be jailed for failing to obey a court order when just before his strokes, our unanswered question written to the court and all lawyers involved was essentially, what is it that you're requiring him to do? Just a whiff of this drama I tried keeping from Rodney was too much for him. He was unusually serene after his first two strokes. That is, until a few months later, he sensed me again wrestling with legal difficulties. Less than a month into my renewed court wrangling, Rodney suffered a third and fatal stroke. I attributed his death to an offense called intentional infliction of emotional harm. Judicial rulings from multiple courts in Indiana have shielded the full circumstances of my husband's death from a private investigation process known as civil discovery, and I've not been allowed a jury trial. In contrast, the former neighbors and their lawyers who portrayed my late husband as a thief are positioned to share most of his estate assets, or help ensure I don't otherwise receive them as sole heir. Per the UN Human Rights Council's Communications Division, there is nothing manifestly ill-founded about Opt-in USA or the contention that my late husband was, and Dr. Jackson with me are, being persecuted through U.S. legal system abuse for our work as human rights defenders. I was removed as administrator of my late husband's estate exactly 3 weeks before the UN Human Rights Council confirmed its willingness to intercede on my behalf and that of similarly situated people, subject to me adequately elaborating on related fact patterns. In the meantime, an $84,000 judgment has been entered against me to punish my challenging of Rodney's death through a wrongful death claim. International law requires it to appear futile to the UN Human Rights Council for me to seek relief from this judgment without international scrutiny, or the Council couldn't even entertain getting involved as it has. Dr. Jackson's family home was encumbered through what he contends was persecution masquerading as a city code enforcement case against him. Encumbered by this litigation, the house was allowed to substantially deteriorate for 5 years, and then about 3 months ago, it was rendered uninhabitable by a fire of questionable origin. Dr. Jackson, having been a lawyer, has not thwarted these outcomes.
The Law Project, Opt-in USA, Dr. Jackson and I, we are all subject to being ejected from the building we call the HRDs Center for Justice, as it is part of my late husband's estate. Estate funds have not been made available to pay real estate taxes and similar levies on the property. No matter how bad circumstances get for Dr. Jackson and me, we won't be reduced to third world living conditions. Some do. The impact of persistent U.S. legal system abuse is intergenerational. So particularly for young people, they can find themselves on a pipeline from foster care to homelessness to human trafficking to drug addiction. But for the rest of us, I doubt that most Opt-in USA constituents reach those depths. But do varying degrees of homelessness, premature death, unwarranted incarcerations, callously severed family relationships, and similar plights seem like the unavoidable fate of privileged people?
And more directly to the point of this video series, do the number of obstacles to justice make a difference if, no matter what, justice cannot be obtained? It may be time to reimagine the face of vulnerability. Until next time, be safe, do good, and ponder how much one depends on the other.